The FBI case was never closed against retired four-star General David Petraeus, who also ran the CIA at one point, and now we may know why. As we learned earlier, federal prosecutors are now seeking charges against the former CIA chief for allegedly providing classified information to his former mistress while she was writing his biography, leaving Attorney General Eric Holder to decide whether he should be indicted. Bringing in our legal panel now to discuss this is David Schwartz. He's defense attorney and former prosecutor, and Kirsten Wilson is a trial attorney. I thank you both for being here, of course. And David, I want to start with you and ask you, should the FBI and DOJ proceed with this investigation?
Absolutely not. They should not proceed with the investigation against the general. They're ruining his reputation. And the bottom line is, you could just go right to the bottom element. Was he trying to harm the United States of America? Was he trying to aid a foreign government? It's ridiculous. They should drop this entire investigation, and they have 10 other hurdles to go through before they even get to that.
Kirsten, what do you think?
I disagree. I mean, right now there's a recommendation by the Department of Justice and the FBI that Holder bring the charges forward. Under the United States Section 798, essentially disclosing the documents to somebody that's unauthorized is a violation. And so on first blush, it looks like the four-star general has violated the law. And so that appears to be the recommendation. A lot of it's going to hinge upon what the information was. And right now there's no information coming forward about that.
And reminding everybody what that information is. It's allegedly the general CIA director at the time allowed his then mistress access to his email account and then giving her access to classified information, allegedly.
Right.
Go ahead.
And it's not just classified information. That doesn't cut it. It has to affect the national security of the United States of America. So we don't know what that information is. Just the emails alone is not enough. But the bottom line is, also the security clearance, there was security clearance for this author. I don't know what level of security, but there was security clearance. But when you cut down, if I'm the prosecutor in the case and I'm looking at this, how are you going to conclude that he was trying to go against the interests of the United States of America? You'll never prove that element. They should trash the investigation.
And President Obama has already gone on record saying that he didn't think any information, alleged information that was allegedly released, put the United States in jeopardy in any way, shape, or form in terms of security.
That's true, and we've heard that. But we're also talking about the director of the CIA, and if somebody has carte blanche access to the director of the CIA's email account, you can imagine the kinds of information that's going through that account. There are also supposedly documents that were found not only on Broadwell's computer, but also in her home. And it's really going to be determinative when we find out what kinds of information was there.
And I agree with Kirsten that there were technical violations here. There are administrative violations. The question becomes, does it morph to a criminal case? And when you look at the criminal statute, you look at the elements, absolutely not. Doesn't come close.
Kirsten, is it possible for them to dismiss the case at this juncture? And if that were to happen, would it be seen as special treatment?
It's not really dismissing the case. It's a recommendation right now that prosecution go forward.
Dismiss the investigation.
Yeah, Holder has the prosecutorial discretion to decide to bring charges or not. It could be seen, there's going to be parties on either side that say it's either favorable treatment because of his status as a war hero, or there's going to be people that saying it's political smear campaign to go after him. So I think the real determination by Holder is essentially a middle ground between what David and I are talking about, which is what kinds of documents were released and what was the intent on releasing these documents, and what was the harm that was caused. And Holder's in a tough position here. He's got to make the call.
He's in such a tough position. Maybe he'll leave it to Loretta Lynch and he'll just leave office. That would be some first decision for Loretta Lynch.
What's the likelihood, though?
Oh, no. The likelihood is that Holder's going to make a decision, and I believe he's going to decide not to prosecute. He has that prosecutorial discretion. I believe he'll conclude that way.
Okay.
And I think there's a real likelihood that that will happen if some of the early reports that the documents that were found were old and somewhat insignificant. There is a high likelihood that Holder will find that way.
Kirsten Wilson, David Schwartz, thanks to both of you.
Thank you.
Thank you.
Eric.